Hi guys, I am Ayushi and welcome to Law Digest. This video is in continuation of our earlier video where we covered some landmark judgments of the year 2020. Just in case you have missed that video, I will attach a link of the same in the top right corner. You can go and watch that video. Continuing with the further cases, let's look at the first case of this video, that is Riya Chakravarti versus Union of India and others. Now we know the main matter of Riya Chakravarti pertains to the death of the Bollywood celebrity Sushant Singh. Now, this matter was decided on the issue of service through WhatsApp. This judgment, basically, the order that we are considering is about the service through WhatsApp issue. The court allowed in this case that a summons can be served, a summons or a notice, कोई भी summon या notice हो वो serve किया जा सकता है through instant telemessenger services like WhatsApp, email, fax. WhatsApp, email, fax के through भी कोई notice अगर आपको दूसरी पार्टी को भेजना है तो आप भेज सकते हैं. The order was passed after the court noticed that there was difficulty in visiting the post offices during the pandemic. COVID-19 के टाइम पे ये केस आया था, तो ये इशू हो रहा था कि पार्टी को सर्विस कैसे करी जाए, पोस्ट ऑफिसेस विजिट करने का प्रॉब्लम था. सो उसको चलते कोर्ट ने ये रूल किया कि समन्स और नोटिसेस जो है वो व्हाट्सएप के थ्रू भी दिए जा सकते हैं. थ्रू व्हाट्सएप such service can be made, and further the court clarified that all the measures that are available, all the methods that are available for a valid service, they should be made ताकि उस सर्विस को वैलिड माना जा सके. For a valid service to be made, all the existing measures should be exploited and employed. Then next is in re Prashant Bhushan case. In re meaning that the court took suo motu cognizance in this case. There was no pleading filed. The court by itself took the cognizance in the case. This pertains to the contempt of court issue. Now, we know that the Supreme Court is a court of record and can punish for its own contempt. So, in this case, Advocate Prashant Bhushan was held guilty of contempt of court because he was held guilty of contempt of court for his tweets that he made criticizing judiciary. Recently, we have also seen that such tweets were made by Kunal Kamra, who's a comedian. उनके respect में भी एक matter already pending है with respect to the contempt of court. So the court formed an opinion that his tweets, they shook the public confidence in the judiciary and thereby amounted to scandalizing the authority of the court, and that is why the court said that he should be punished. The bench repeatedly urged, द बेंच ने काफी बार ये बोला प्रशांत भूषण को कि वो एक अपॉलॉजी ले कोर्ट के सामने, बट देन ही वाज एडमेंट ऑन हिज स्टैंड. प्रशांत भूषण का ये मानना था कि उनके व्यूज हैं जुडिशरी के बारे में, ही कैन पोस्ट देम फ्रीली एंड ही इज विलिंग टू अंडरगो एनी पनिशमेंट फॉर द सेम. प्रशांत भूषण का ये कहना था ये जो व्यूज हैं ये मेरे अपने हैं एंड मैं इन्हें वापस नहीं लूंगा और मैं इनको कहीं भी कहां पे भी बोल सकता हूँ. So then Attorney General K.K. Venugopal, because the court felt that it amounted to scandalizing the court, then Attorney General K.K. Venugopal requested the bench that he should not be punished because he's such a senior advocate and has a good standing in law. And ultimately what the bench did was they sentenced him to a fine of ₹1 का fine उनसे मांगा गया as a part of punishment in this case. Then moving on to Madras Bar Association versus Union of India. This related to amendment of Tribunal Rules of 2020. The court found that the Tribunal Rules of 2020 जो हैं, they are not adequate. The court felt that these rules are not adequate and it is necessary कि इसमें अमेंडमेंट करी जाए. ये जरूरी है कि इसमें अमेंडमेंट करी जाए ताकि इंडिपेंडेंस और एफिशिएंसी ऑफ ट्राइब्यूनल्स को बढ़ाया जा सके. फॉर द इंडिपेंडेंस एंड एफिशिएंसी ऑफ ट्राइब्यूनल्स इट वाज नेसेसरी to make amendments to these rules. So the court passed directions to constitute a National Tribunal Commission (NTC) की establishment के लिए कोर्ट ने बोला, and it allowed that lawyers जिनके पास एटलीस्ट 10 साल की प्रैक्टिस का एक्सपीरियंस है, they become judicial members in the tribunal. वो इस ट्राइब्यूनल में as judicial members serve कर सके. Then moving on to Satish Chandra Ahuja versus Sneha Ahuja. In this case, it relates to share of wife in the household of the relatives. So the court said that the wife is also entitled to claim a right of resident in a shared household belonging to the relatives of the husband. So, if the relatives of the husband are residing in a household, then the wife of the husband also has a share in such property. And through this, the court overruled its earlier judgment in SR Batra versus Taruna Batra case. CLAT PG aspirants के लिए ये important है. It is important for CLAT PG aspirants to remember that which case was overruled in which case, because ऐसे क्वेश्चंस क्लैट पीजी के एग्जाम में काफी आते हैं एंड जजमेंट्स को थोड़ा डिटेल में देखने की जरूरत है फ्रॉम द पॉइंट ऑफ व्यू ऑफ क्लैट पीजी एग्जामिनेशन. देन मूविंग ऑन टू विद्या दरोलिया एंड अदर्स वर्सेस दुर्गा ट्रेडिंग कॉर्पोरेशन. अब इस केस में क्या हुआ था, ये बोला गया था, in this case it was held that the landlord tenant disputes are arbitrable. So if there is a dispute happening between a landlord or a tenant which is governed by the transfer of property act, TPA act के अंदर कुछ लैंडलॉर्ड टेनेंट डिस्प्यूट है, सो ये डिस्प्यूट जो है वो आर्बिट्रेबल होगा, एक्सेप्ट कभी अगर स्पेसिफिक फोरम जो है वो रेंट कंट्रोल लॉज में स्पेसिफाइड है. So every dispute between landlord tenant that falls under TPA is arbitrable. और कोर्ट का रीजन क्या था इसके लिए? द कोर्ट रीजन दिस जजमेंट विद द फैक्ट दैट दीज राइट्स, जो एक्शन ले सकता है लैंडलॉर्ड और टेनेंट के बीच के डिस्प्यूट्स में, ये जो राइट अराइज होता है, दिस इज नॉट फ्रॉम राइट इन रेम, दैट इज राइट इन जनरल नहीं है, ये राइट इन पर्सोनेम है. इट इज between the parties. Like we say, a contract creates right in personam. In individual parties, the rights is created, and the right is not available against the general world because it is a contract between the parties. So similarly, a landlord-tenant dispute जो है, this is a right in personam, and therefore this right is arbitrable, and the court overruled its earlier judgment in Himangini Enterprises versus Kamaljeet Singh Ahluwalia. CLAT PG aspirants need to remember this. Then moving on to the next one, Paramveer Singh Saini versus Baljeet Singh. This judgment is about installation of CCTVs in the police stations. The court ने ये मैंडेटरी कर दिया कि सीसीटीवी कैमरा जो है वो पुलिस स्टेशन में और जो भी और इन्वेस्टिगेटिंग एजेंसीज हैं जैसे एनआईए, सीबीआई, एनसीबी वगैरह में ये जो कैमरास हैं ये इंस्टॉल करे जाएं. द कोर्ट मेड इट मैंडेटरी फॉर इंस्टॉलेशन ऑफ सीसीटीवी कैमरास इन पुलिस स्टेशंस एंड इन्वेस्टिगेटिव एजेंसीज. द कोर्ट ऑर्डर दैट इन एनी सर्कमस्टेंस, जहां पर ये दिख रहा है कोई ऐसा सर्कमस्टेंस है कि ह्यूमन राइट वायलेशन हो रहा है, तो विक्टिम के पास ये राइट है कि वो सीसीटीवी फुटेज की जो कॉपी है, जो इंटेरोगेशन हुआ था उसकी फुटेज की कॉपी जो है वो ऑब्टेन कर सके, और दे कैन अप्रोच नेशनल एंड स्टेट ह्यूमन राइट कमीशन फॉर द सेम. सो इन केस पर्सन फील्स दैट हिज राइट्स are being violated, his human rights are being violated, he can seek a CCTV footage from these cameras that are there and can approach the NHRC or the State Human Rights Commission for the same. The installation of CCTV camera has been mandated in any office, not just these. The court said that it has been mandated in any office जिसके पास power है, the office that has power to arrest and interrogate an individual, वहां पर CCTV cameras होने जरूरी है. Then moving on to the next one, Internet and Mobile Association of India versus Reserve Bank of India cryptocurrency judgment. Now cryptocurrency was banned, but through this judgment the Supreme Court lifted the curbs imposed by the RBI. RBI ने जो curbs impose करे थे कि banks और NBFCs जो हैं वो virtual currencies में deal नहीं कर सकती हैं and services नहीं provide कर सकती हैं to crypto businesses. So this judgment basically said that the banks and NBFCs, they can deal in virtual currencies, in cryptocurrency, and the court said that the RBI circular that came earlier that prevented the entities that were engaged in trading of virtual currencies, that circular was liable to be set aside on the ground of proportionality. So the court said that on the ground of proportionality, जो RBI का पहला circular था जो regulated entities को stop कर रहा था from providing banking services to those people who are engaged in virtual currency, जो virtual currency में deal कर रहे हैं, उनके respect में इस RBI circular को withdraw कर लिया गया और उसको set aside कर दिया गया. Then moving on to the last case, Indore Development Authority versus Manohar Lal and others. So this case pertained to Land Acquisition Act proceedings. Now what was said here was that the Land Acquisition Act 1894 के अंदर जो भी पैसे जो compensation अगर ट्रेजरी में डिपॉजिट किया गया है, it will not lapse. कोई भी अगर एक्विजिशन हुआ है इस एक्ट के अंदर और ट्रेजरी में पैसा दिया गया है तो वो एक्विजिशन जो है वो लैप्स नहीं होगा. How landowners cannot insist that deposition of the amount in the court is necessary, that this money should have been deposited in the court to sustain the proceedings under the old act. So the court said that even if the state fails to deposit that compensation in the landowner's account, it will not be a valid reason to lapse the proceedings. And the court said, court ने ये बोला कि अगर landowner के अकाउंट में वो पैसा नहीं आया है, कॉम्पनसेशन नहीं आया है, उसका मतलब ये नहीं है कि प्रोसीडिंग्स लैप्स हो जाएगी. अगर वो पैसा ट्रेजरी में ऑलरेडी डिपॉजिट कर दिया गया है अंडर द ओल्ड एक्ट तो वो प्रोसीडिंग तब भी वैलिड रहेगी. So with this we come to the end of this video. We covered all the important landmark judgments of the year 2020. In case you have any further doubts or queries, you can mention the same in the comment box below. And all those who are enrolled for our legal current affair courses, this PDF for these judgments, and also there are some other judgments as well, the same has been already uploaded in your course.